What is the fundamental difference between a limited liability company and a corporation? What is the fundamental difference between a limited liability company and a corporation? This is a question that I get often. I also get variations of this question that present different issues and opportunities to educate people and explain things to them. But if I were to stick to this question of what is the fundamental difference between a corporation and a limited liability company or LLC, I would say, of course, as a lawyer, there are so many differences, and these differences are fundamental, right? It's true. There are a lot of significant and material differences between the two. But if I were to distill it down to one thing, it will be this. At a fundamental level, corporations are creatures of statute. There are statutes set up that define what must occur and happen when it comes to a corporation. They define the defaults for a corporation unless specific actions are taken. These are business entity types where statutes were established for a significant period of time that govern how the directors and the shareholders relate to one another, the rights that the directors and the shareholders have to one another, the relationship of those shareholders and the directors to the business entity, to the corporation itself, separate and apart from them being a director or a shareholder. Those statutes have been in existence far longer than what we would refer to as limited liability company statutes. At its core, a limited liability company or LLC is a creature of contract. Initially, there were not statutes that defined what must occur or what duties and obligations must exist when it comes to limited liability companies. In the beginning, limited liability companies were primarily formed because the parties came together and they signed a contract saying this is the type of entity that we have and this is how we exist in relationship with each other. Over time, states began to recognize it as a business entity type, but there were no limited liability company statutes for many of those states. They would simply recognize that such an entity could be formed. Over time, different states adopted more and more details concerning the requirements for a limited liability company. But that fundamental difference still exists. There are still many ways where we see that the historical origins of a corporation versus an LLC have an impact today. So if you sometimes wonder why LLCs have to go through more hoops in some states than others when it comes to their technical requirements, it's because initially they weren't really recognized, where a corporation was seen as a transparent, recognized business entity type based off of statutory law. It's also part of why the IRS does not recognize LLCs as having their own taxation type. You have to borrow from one of the other taxation types. For example, a corporate taxation type or a partnership taxation type. There is no LLC taxation type specific for LLCs. Instead, it's borrowing from those other taxation schemes. So this is the fundamental difference. From inception, historically, corporations were creatures of statute. Statutory law established them as a business entity type, and they created a series of robust regulations and requirements for the duties that shareholders and boards of directors have towards the corporation. LLCs were more private, contractually based agreements between individuals, where later different states established laws and regulations concerning how those LLCs can and should be governed. But even to this day, the regulations at the state level that are embodied in statutes are much less onerous and specific than you would typically find for corporations. So that fundamental difference is down to history, but the history is not completely in the past. We see it show up every now and again when it comes to business entity forms. What does the fundamental difference between LLCs and corporations have to do when it comes to selling your business down the line? Well, for one, you will go through a due diligence period concerning the governance of your business entity, and it changes the nature of the type of information that you have to display. So instead of providing, for example, an operating agreement, you will perhaps need to provide a bylaws and the certificate or articles of incorporation, depending upon which state you were formed in. It will change that part, but it will also probably entail a different focus for due diligence when you're dealing with an LLC versus when you're dealing with a corporation. I can tell you in my experience, typically what I found is that LLCs will often sell their assets versus their membership interest, and corporations will tend to sell their membership interests. That's not always the case. It's not a hard and fast rule, but I do think it's interesting, and it would be interesting also to see what studies show. Does there tend to be a connection between an asset sale and LLCs versus an equity interest sale, a stock sale, and corporations? Could be, could be. But in terms of my own anecdotal experience, that's what I've seen.